Sorry.
What does the mediator do? The mediator is not a judge or jury. A mediator of authority and responsibility, creativity. What many participants like about mediation is that the
Doing well. How are you?
All right, so sign in, get credit for showing up. Was there something going on today, or is a lot of people gone? Was there something fun that the rest of the seminar about? No, it's just the end of the semester, like, I don't know, kind of absences, money to burn. I think it's so, what do you have, 7? Is it 7? Which is just, you know, when I was in law school, they did not take attendance. Back in the day, right? They didn't take attendance. And nobody was lying. Like, you would not, like, maybe if you had surgery, you missed the fact, maybe. And, you know, nobody, and it's just such a funny thing, you know, different. It's just different. But I liked it back then because, you know, I told my dear, I don't think you should have attendance. Come down to class and go to class. If you don't show up to your class, you know you should probably switch your class around. But we have the rules that we have. So, let's see. I'm going to keep going through this video on mediation. You know, I've never done a mediation today, but the mediation, every time I go through this tape, I'm going to do mediation so a little bit more. And I did send you an email. I want to get all the groups set on Monday so I can hand out the out-of-class negotiation on Monday. So I just sent you an email. Everybody who has sent me an email with a group of 3 people, I put it in. I just pasted it into a file. So if for some reason your name is not there and you sent in a group of 3, then please just send it to me again. That just means somehow I've lost it. So send me that group of 3 again. Look at the list because there are 3 or 4 groups that need a 3rd person. So if you know 2 of those people, if you'd like to be their 3rd person, please tell them and also alert me so I can update my list. It is now a group of 3 instead of 2. And if I don't hear anybody that I don't hear from by I think I said tomorrow at 6 p.m., I'll just go ahead and assign you randomly to groups, which will not be a bad thing at all. It's the negotiation. It's like the ones we've done in class. You get your role, and then the 3 of you will go off and negotiate it. And in some ways, it might be good if you're randomly assigned. So you can get randomly assigned. Sometimes it's the groups that get together oftentimes are friends and whatnot. And sometimes being randomly assigned to a group that you don't know as well can actually make the negotiation slightly more realistic. Although I really feel it doesn't matter in this one. Even if you're friends or whatever, it really doesn't matter. I think this is a really well-written negotiation. I think it's a pretty realistic negotiation. It's kind of a pie distribution situation, which I think is quite common with people practicing. And so you'll be a vigorous advocate for your client. And I think that I like this exercise. I think it draws on a lot of the sort of concepts and tools and theories that we talked about this semester. So I think it's a good sort of capstone exercise. So I'll be handing all that out Monday. You can do that anytime during the rest of the semester that you want to. Any questions about any of that stuff? Or do we have any other administrative matters we have to take care of before we go on to mediation? Okay. Yeah.
Oh, you had mentioned at the end of last class that you discussed ways that you can incentivize people to not lie to you.
Yes, and I don't know if I call it, I'll talk about that today.
Okay.
well, it's just an article that I wrote online in negotiation and sort of the conclusion that we need. Like, it's kind of a bitter, it's kind of a cynical conclusion I came to. Is I don't think in a way it's particularly helpful to have all these rules. I think people lie, and regardless of the rules. And a lot of people don't know the rules, and there's a lot of disagreement on what the rules are. And I'll show you some data from a survey that was taken just with 4 different very short sort of scenarios, ethical scenarios, and I presented these to a group of a very cross-section type group of kind of lawyers and judges and academics to see how they would respond to these 4 scenarios. And as you'll see by the outcome that I got when I sent this out to people, people are all over the board. So my sense is people don't necessarily know the rules. Even if they know the rules, they don't necessarily follow the rules. And so I don't know why we spend so much time in law school drilling people on the rules when I think what we should teach people is teach them to learn that people will lie to you, that they have a strong incentive sometimes to lie to you, and to be more of in a defensive posture. What can you say to people that will maybe make it so that they're less likely to lie to you? And a lot of it has to do with sort of reminding them, hey, you might be crossing the line. And there's certain people you can really give to. But we'll discuss that after this mediation video. So again, I'm going to stop this as we go along. I think a lot of people have a different take on mediation, and I have my own sort of views that I'll throw in here. People at Lakeside Mediation, which I'm pretty sure is in Austin, they do a lot of mediations. I think it's a pretty good introduction to this. I think that many of you, no matter what area you go into, even if it's not practice of law, many of you will be involved in mediation. So you'll be looking at policy mediation, or you'll be a party yourself. Many of these disputes now are resolved through mediation, and it's all really money now. So it costs so much less to deal with a problem through mediation than it does through litigation. That I think it's going to become more and more prevalent. And most courthouses now have these annex mediation programs where they're becoming sort of more and more integral part of the courthouse, where the judges are basically saying, look, you've got to go to mediation for a day before you get in the courtroom. I'm not going to give you courtroom time until you try to resolve this through mediation. So I think that it's, and when you watch this, and when we watch them talk about mediation, what I want you to think about is sort of strategically, right? If you have a client who's going to go to mediation, what do you need to tell the client? Because clients, you can even talk to most lawyers. They won't really be able to tell you the difference between negotiation, mediation, and arbitration. And the people who go to law school for 3 years won't be able to tell you the difference. And certainly your client won't know. So you're going to have to tell them what this process is about and walk them through it a little bit. Oftentimes it's a negotiation just to get them to attend mediation. So we were at 4 minutes yesterday. They're just going and just telling you the 10. They break it down into sort of 10 sections to give you the intro on mediation. And then I'm going to stop it from time to time because I have certain disagreements with what they say.
Parties themselves, be they individuals or institutions, have a direct hand in determining the outcome or resolution of a dispute. For the next 10 minutes, let us walk you through the stages of the process. While some mediators may approach the process differently, you will find that things generally unfold like this at a mediation. Greeting the parties, joint session, mediator's introduction, opening presentations, information gathering, separate caucus, reality testing, negotiation, memorandum of agreement, closure.
Good morning. How do you all do? You arrive for your mediation, you'll be greeted by a receptionist. Usually, you'll be escorted into a private room with only you and your counsel until all the parties arrive. The mediator or a receptionist will then escort all the parties and their counsel to a conference room for what is called the joint session.
Once everyone is seated, the mediator will ask each party to introduce themselves and indicate in what capacity they appear at the mediation. For example, a party might say, my name is James Smith, plaintiff in the case. The purpose of these introductions is to make sure that the mediator knows who everyone is, as well as the other parties. Once the introductions are made, the mediator will make a mediator's introduction, which will last about
conversation if we talk about, Bill and Mary versus Ms. or Mr. Or, the attorney constantly saying my client. I think that I think that it becomes not necessarily more friendly when you're using first names, but I definitely think that it has a slightly different dynamic to it. And that I think that even those small little subtle things can play a role in people kind of picking up and listening to the other side and to actually be willing to have a conversation. By the way, I've never had anybody say, when I propose at the beginning, nobody says, no, I'm really rather be formal. I want to go by this. Everybody's like, yeah, fine, I'll
A mediator's introduction is designed to accomplish several things. Most mediators begin with a brief discussion of their background and qualifications.
By the way, is this volume okay? Can you move it up a little higher? Volume okay?
So the parties who are often meeting the mediator for the first time have a better idea of who the mediator is.
My role in this process is to serve as a neutral. I'm not going to be the judge, I'm not going to be the jury. I can't twist your arm or force you to settle the case in any way. My job, essentially, is to foster communication between you, the counsel, and the other side, and see if we can't find some common ground to settle this matter today.
The mediator will then explain his role to the parties so that the parties will better understand the mediator's job. The mediator will explain neutrality, confidentiality, and then provide a preview of how the process will unfold. The mediator will often explain the benefits of the mediation process and set some ground rules. Such rules might include a no interruption rule and asking the parties to address each other in a civil manner. The mediator may finally ask the parties for certain commitments. The mediator might ask whether the parties are there with full authority to resolve the dispute, or the mediator might ask if all the parties are willing to give the process a good chance to work.
That's what I was talking about before. The whole standard of good faith effort. If you're part of the mediation program that has anything to do with the courthouse, the standard will be to you, the client, take a good faith effort in the negotiation. So when the mediator says, you don't, those two questions, you have full authority. I mean, usually the party has authority to make a deal. They'll say, yes, I have authority to make a deal. And it's just that. I mean, tell your client, I call it making the noises of good faith. You need to say, yes, we're here. We want to be engaged in this process. We hope that it works. And if we can come to something that we believe is fair and reasonable, we'll certainly make a deal today. That's all you need to say. And that is I think, meeting that test of a good faith effort. You don't necessarily need to throw out offers. You certainly don't need to accept any offers. I mean, I think that a lot of people are afraid of mediation because they think once this process starts, we have to come up with a deal. And I'm at the end of the day, so you just have to really advise your client, no, a good faith effort is just showing up, telling them that you're willing to listen to everything, and that if you hear of a deal that's reasonable and fair, certainly you'll go with it. Maybe if that's the deal that you have to hear before you're willing to agree to it.
I can't really say at this point how long today is going to last. I'll have a better feel for that when we get into independent caucus, but I think it's important for you to remember that whatever time you spend here today is a good investment.
By the way, his earlier statement about his line of, I'm not a judge, I'm not a jury, I'm just here as a neutral to bring you together so you guys can have a conversation. That is what everybody says, and that's sort of the language that they teach you, especially in law school. I've got to say, though, that I think that mediators who are successful in the marketplace add something else, either in a joint session or in the private sessions, which they call the caucus. They'll say something like, look, I'm a retired judge. I've seen 1,000 of these in my courtroom. I know how they will go. I pretty much know what will happen if you go to court. So that basically both sides then have more confidence in the mediator. Like, oh, the mediator has credibility. He or she knows what would happen if we go to trial. So the nice thing about it is that the lawyer is then saying to him or herself, oh, great, I have a mediator who can convince my client to go with a deal that's reasonable. Because as a lawyer, the worst thing that can happen is the other side's making a proposal that's very, very reasonable, maybe even better than you'll ever get in court. You know it, and you cannot convince your client. And it's great to have a mediator who has a lot of credibility who can say, look, I'm a former trial judge. If you go to trial, you'll never get a better deal than this. And they'll say stuff like that in caucus too. try to get both sides to come together. But it's different styles. I mean, some of them, depending on their own style, they'll reveal in the opening session how much they're going to be, it's called being directed. They will reveal how directed they will be during the mediation.
It may take us all day, but it certainly won't take us the weeks or months that a trial will take. You have an opportunity to dispose of this dispute in one day. And I'd like everybody's commitment that they're going to stick around for as long as it takes today and give this their best shot at trying to reach the settlement.
Of course. And as I said, the only time I've ever heard anybody get into trouble, the only thing they say that there's confidentiality, so nothing that you can't be subpoenaed, the mediator cannot be subpoenaed to go to court or anything like that. And it is confidential, right? What's said in mediation is supposed to be confidential. It's supposed to go nowhere else. The only thing that will ever get back to the judges, if you don't, because I have heard of stories where people will say things like, "This is BS. I don't need to be here. I'm leaving. I know it's a court annex thing. I'm leaving. I want to go to trial." That information will go to the judge, and there can be sanctions and all sorts of things. It's like, no, you have to go to mediation and make a good faith effort. So anybody who wants to try that with mediation, just don't do it. Sit there and grin and bear it. By the way, if it's very, I think that the mediators, they're not going to keep you there for hours and hours and hours. It's completely unproductive. They will know if you say, we're here, we want to make a good faith effort of this, if you hear a reasonable proposal, we'll go for it. The mediator can tell right away if the zone of possible agreement is huge, right? You're on completely opposite sides. They're not going to go for 8 or 10 hours when they see absolutely no movement. They'll say, fine, you came here, you did a good faith effort, but you have a very different sense of what's reasonable on both sides. Have fun, go to trial.
First, the time involved pales in comparison to the days, weeks, months, and even years of pre-trial matters and trial. And the mediation process takes place in a private, comfortable setting. You should check with the mediator and your counsel regarding dress, but comfortable business casual dress is usually appropriate, and you should make contingency plans if the session continues into the evening. So what happens in the joint session after the mediator concludes his introduction?
At this point in the process, I'd like to hear from each of you about how you view this dispute. Generally, at this point, we'll start with the person who brought the claim.
It's a small thing, but this whole thing about dress, that's fine. Every mediation I've been to, people are pretty informal dressed. There are some business mediations, of course, where people doing business attire or whatever. I don't think that the dress is that important. But this, I do want to say one thing. People get a huge advantage in that in doing things like mediation, just wearing the other side off. People get tired. They kind of want to go home, they want to be able to get tired. And so, this seems silly, but I would bring food, I would bring snacks for breaks. And you could literally wear the other side of the out. The former Secretary of State was one Christopher, that was Christopher Warren, one Christopher. Doesn't matter. Whichever way it is. Which way is it?
I think it's Warren.
Warren Christopher. Okay, so he would talk about how, right, just his ability to sort of, I mean, this guy would have to go globe trotting and negotiate with, tough-minded people around the world on behalf of the United States as Secretary of State. And he said once in an interview that one of the best advantages that he had in negotiation was simply his ability to go for hours and hours and hours without food and sleep. And he would tell people, like, no, we're going to get this deal done. We're not leaving to get this deal done. And you can imagine that in Afghanistan. And people just like, I'm tired, it's fine, So, I mean, keep that in mind. It seems like a small thing, it's huge. I've heard of, mediation sessions where they'll bring it, like, it goes on for a couple days. They'll have a plate of cookies there every morning, right? And then, the third day people come in, they say, cookies there, like, people are breaking down. Where the cookies? These small things they make a huge difference. And Angela Betta, who wrote the casebook, the lead author of the casebook, she had a whole series of mediations she was conducting. It was actually, there were some that this big in terms of, some of them were over in England, and some of them were conducted in California on the coast. So, for whatever reason, she set it up. So the ones in England were done in these elaborate kind of offices, with fancy office. And then the other ones were literally done on the beach, like a kind of poolside situation in California with nice food and drinks and all that. The other one was in the business office, didn't have food. These, the rate of settlement was so much higher, and the only factor that she figured for these were scores of mediation cases. The only difference was the atmosphere of the food. So don't be dismissive of these things. It can make a huge difference.
You know, opening presentations of mediation are different from opening trial statements. Keep in mind, the purpose of mediation is to reach a resolution and not to persuade or influence the mediator. One of the true benefits of mediation is it provides your lawyer with his only chance to speak directly to the other side and for opposing counsel to speak directly to you.
Let me just say one thing. A lot of people have a misunderstanding. I was in so many mediations that the counsel felt like they were talking to me, like somehow I had some sort of power over the mediation. Like you said, they're trying to persuade me. That's not what a mediation is about. If I were you, representing your client at a mediation, I'd say that the shorter the opening statement, the better. And it's not about the mediator. People will go in, they might be in sort of advocacy mode, or maybe even sort of hostile mode, and kind of directing that towards the mediator. The mediator has no power, and he's not going to be the decision maker. This is simply a conversation. Pretend almost like the mediator's not there. You're having a conversation with the other side. What you're trying to do is get the other side so that they'll listen to you, so be friendly towards them, so that they'll actually buy what you want them to do, right? And go along with what the deal that you're proposing. That's what a mediation is.
You will be afforded an opportunity to speak at the joint session, but that is a decision that you and your lawyer will make before you arrive. Usually,
I have to say this down. I'll say it again. They talk in these videotapes and book and everywhere else. They talk about mediation as if it's just this amazing thing and there are no downsides to it. I will tell you, and it's because I sort of have a cynical about it, and I think that it's good. It should be. Here's the downside of mediation. Be careful with this. A lot of people, they're not serious about mediation. They want to use it to petition. They want to use it as a fishing expedition to find out how you might approach the case if you do go to litigation. So you always have to be careful when you're giving away information. They'll tell you, of course, it's confidential, it's confidentiality, it's not confidentiality, it's going nowhere else. But the other side, if you're still on the other side, you essentially in mediation might be sort of, in a way, accidentally kind of giving away your whole game plan if you do go to court. So be careful that when I said at the beginning about negotiation, it's all about information. And the negotiator's dilemma, there's a term for it, is what should I reveal and when should I reveal it? That's the whole tension in negotiation. The reason the negotiator's dilemma exists is because this. If you give away information, then you can increase the size of the pot, right? If you give away information, you find out what do you want, what do you value, what do you not value, then you can sort of increase the size of the pie and divide it up in a way that each party gets what they value most, and the other party gives away what they value least. Well, that's, value creation, the whole, like chapters about this. And it all stems from giving out information. But the dilemma is, when you tell the other side what you want and how you rank things and all that, they then that's a form of leverage. They now know, oh, that's valuable to you, well, you're certainly going to pay a high price to get it. So you have to be careful. You want to create a bigger pie, but you also don't want to be taken advantage of. And in all respects, think about with your client, what do we really want to reveal to the other side? And by talking about different things in mediation, to what extent are we giving away our game plan, or personal information, or a legal case, or whatever, if we do go to litigation? So think about it strategically. And I do think that a lot of people go to mediations just to take advantage. Frankly, they have no interest in settlement there. All they're doing is trying to collect information and take advantage of the other side. And warn your client of that.
I think the mediator will ask the lawyers on all sides to make opening presentations.
Mr. Schmidt, I know that going through a lawsuit is, for both sides, a very daunting and painful process at times. This is my one opportunity, sir, to be able to sit down with me, with your lawyer present, perhaps before this case is going to be tried in a few weeks, discuss whether there's any opportunity for us to get this resolved. The case is relatively simple, as you know from your pre-mediation submission. It's my client stopped at a red light, automobile accident case where she was rear-ended by the defendant. In this particular case, it's been our allegation, and it's very clear that at the time of the accident, you were using the phone. It's undisputed that you were talking to a corporate client at that time, and you told the police officer at the time that you were distracted by the cell call. Cheryl, why don't you respond to that as the defense lawyer? Tell me how you see the defense in this case going.
I'd be glad to. We're not really here to use the liability issues. Our issue is the damages. We have seen medical records totaling approximately $15,000, but the demand in this case is, I believe, $350,000, and in our view, that is excessive.
These presentations usually take 10 to 30 minutes per lawyer, and your lawyer's tone will likely be conciliatory. This is not a sign of weakness, but rather the tone is consistent with the very nature and purpose of the mediation process.
By the way, setting that tone, you talked about laying down rules at the beginning. I think I generally only say three things. No interruptions, no name calling, and if you want to say something, hold off, you will have the opportunity to say it. So here's paper, write down what you think of, and you're going to have an opportunity to say it. Those three things. No interruptions, no name calling. And if you say those three things, it's surprising. And if you say, look, those are my only three rules, but I'm going to strictly enforce them. And if anybody interrupts at the beginning, and you as a mediator say, look, I said at the beginning, I set those three rules. You only have to enforce those rules once. And people will be civil. But I don't think you need an elaborate set of rules, and I think those three cover them all. And I do think if you give them this idea, look, you will always be able to say what you want to say. Here's paper, write down, you will have thoughts. And the other side is talking, please write down your ideas so that you can share them with us when the other person will stop. So that they have this idea, you're simply going to go back and forth, and there's going to be no interruption, and there's going to be no name calling. It's surprising, even with people who've been in a contentious situation for years, they would be able to have a conversation for a day. The lawyers on all sides are really attempting to do two things. First, the lawyers want to make sure that the mediator understands the dispute. More important, each lawyer wants to make sure that the other party appreciates the extent and the nature of their risk. When the other lawyer is speaking, you will likely not agree with what that lawyer is saying. But this is not a trial. Opening presentations are not to be interrupted, and it is essential for everyone to at least listen to what is being said, attempt to walk in each other's shoes a bit, and utilize these presentations to objectively evaluate the dispute. The lawyers on all sides, because it is a mediation, should be courteous, respectful, and civil.
After the lawyers have made their opening presentations, the mediator will ask each party whether they wish to add or contribute something during the joint session. Again, you should discuss with your lawyer whether you should speak at this moment. If your lawyer encourages you to do so, then you will have an opportunity to express your feelings about the dispute, and this may be your only chance to directly address the decision makers on the other side.
By the way, this whole idea, it's a strategic decision, right? You talk as if the lawyers are always going to be the ones who present the case. They're always going to be the ones who speak first. That's not necessarily the case at all. In most of my mediations, I would tell counsel, I would lay it out at the beginning. Counsel, we're glad you're here. We're going to call on you for legal advice probably throughout the day, but probably most of the conversation will be between us. I mean, I would just say that. Now, the lawyers, they can do whatever they want. They can. I think that sort of sets a tone for, okay, I don't have to be jumping in on this, which I think that it did pretty effectively. And as I said before, I would have them seated, right, so that the lawyers were on the outside and the clients were, both sets of clients were right next to me, so that the three of us could constantly be having a conversation, and then we turn to the lawyers when we needed advice from counsel. But you have to strategically think about, all right, you have to think about, okay, how well will my client present if he or she talks during the mediation? And you just have to be strategic about it. Okay, if it does end up in litigation, they're going to be assessing my client for how good he or she is going to present at trial. I mean, all those kinds of things. Maybe you have a client where you say to yourself, I don't want this person to talk much. I mean, but it's those kinds of negotiations that you have to have with your client and explain the situation to your client. I mean, you're probably going to have a client who either wants to talk a lot or very little. But have those conversations before you go into the mediation, because I saw many mediations where that conversation did not take place, and there was a lot of tension between lawyer and client about the client wanting to talk more, or the lawyer trying to sort of shush the client, which can be a whole weird sort of tension throughout the day if you don't have that conversation. It's really a strategic kind of conversation you need to have.
What really bothers me about this whole thing is that I was sitting at the red light, completely stopped, and looked up in my rearview mirror and saw this guy coming straight for me with a cell phone in his hand. That, to me, I knew at that point that he was not even paying attention to the red light and was not even going to try to stop. And all I could do was brace myself for the impact. I know it happened so quickly, and at the same time, it's like slow motion to me. And I relived that through all of the time that has passed and all of the work that I've had to go through to try to regain my health. And I guess I just want some type of acknowledgement of the fact that it's not just the money at all at this point. I think that it's also acknowledging the fact that I was injured and that it was his fault and that he was conducting company business when this injury happened. That's what's bothering me about this whole thing.
The fact is, it's a car accident. I'm sorry. I feel terrible about what happened. I tried to find you in the hospital and make sure that you were doing okay. I was not able to determine where you were in that hospital. I truly feel bad for what happened. But your lawyer has demanded a totally unreasonable amount for this car wreck. He's asked for $350,000. He's trying to hold my company responsible for this. This is a car accident. This is not company liability. I built that company from scratch. Now, y'all may not understand what that means, but I put my sweat and blood into that company. And there are other people who depend on that company for their livelihood.
By the way, when you watch this mediation tapes, you look at it and it's sort of, they bring in these issues and you say, well, kind of going off on a tangent. And what they're trying to do is portray what realistically happens in mediation, which is people bring a lot of sort of emotional issues, side issues, they go off on tangents left and right, and they're trying to give you a little bit of a sample of that. That's a lot of what will happen in mediation. As a lawyer, you'll be constantly saying, this is so irrelevant. This has nothing to do with the law, this has nothing to do with sort of a legal outcome, this has nothing to do with what would happen if you went to trial, this has nothing to do with what the jury would be interested in. You'll say that 1,000 times during the day, but just so you know, I think that once the air is sort of cleared of some of these sort of side issues, then if this astonishing thing does happen where they start to hone in on the stuff that is relevant, and they can oftentimes come to an agreement. And the other thing that's fascinating is oftentimes, especially if I make this sort of case that, hey, counsel will talk to you and will lead you, the people, they'll make an agreement that doesn't necessarily follow what the law would tell them to do at all. And oftentimes, even though the law might be very relevant, they'll come up with an agreement that doesn't look anything like it would look if it was settled in a court of law. And that's sort of the advantage and the disadvantage of mediation. And that's another warning that you should give your client. Look, if we went to trial, this is possible. This is the probable outcome. Right? There's like a 50% probability that you'd end up here. There's an 80% probability that you'd end up at least here. Give them these kinds of sort of objective criteria, because otherwise they might make a deal that they think is reasonable with the mediation that looks nothing like that. And the mediator, as long as it's not illegal, will say, fine, that's the deal you both want to make. Let's reduce it to a contract, and then it goes off into contract law and can be enforced in court under contract. So just be careful. I think that's that's what happens a lot in mediation.
Listen, just because I was using a cell phone has no bearing on the damages in this case. I think it's absolutely despicable that your attorney has come in here asking for $350,000 when the medical expenses add up to $15,000. I just don't understand it.
While you may need to express some difficult and personal emotion, your tone should be, if at all possible, respectful and civil.
I did spend several days in the hospital. I was transported by EMS.
By the way, I will say, a lot of these situations can be very emotional and can be very contentious. I was doing divorce mediation. There's nothing more contentious than kids and money and infidelity and all the stuff that oftentimes come up in these kinds of cases. Very emotional, very, very contentious. And I don't care if people get emotional, right? If they follow, I think you can be, as long as you adhere to this rule of no name calling and no interrupting, that's fine with me if people get emotional. And people can cry, people can scream, and that, depending on the case, that will happen. And by the way, people say, well, I'm going to do business law because there's no emotion there. Trust me. I mean, oftentimes, like people say, I'm good at business. It's like dating a child. There's an emotional attachment oftentimes in business. It's at least equivalent to some of these family law cases. So you're not going to escape emotion in these cases, in these disputes. There's going to be emotion.
I've had a lot of physical therapy. I've gone through this time at work, not just in the days after the accident, but in time that I've had to take doctor's visits, time off for physical therapy. I've had pain in my back and in my neck. I've not been able to do the things that I would have normally done.
Tom, would you like to add anything at this point?
I sure would. Listen, I am sorry for what happened. It was an accident, though. I didn't intend to hit you.
Well, we've talked about this before. The whole thing of apology, it's different in different states. Most states have now passed these laws that you can say apologies, and it's not equal to an admission. I think 40 of the states have passed these laws, so people have much. There was a time when your attorney would be like, hey, don't apologize. This is equivalent to an admission or whatever. It's much different now. There's a lot more apologizing going on without potential legal difficulty.
I was on a cell phone, but let's get real. Cell phones are a reality today.
Keep in mind that the mediation process belongs to everyone, and you play a very important role. As your lawyer will tell you, strong feelings aside, a fair settlement is always in everyone's best interest, yours included. Occasionally, after everyone has spoken, the mediator may ask some questions to clarify points and issues. This is part of the information gathering process.
After the joint session, the mediator will likely split the parties and their lawyers into different rooms. This part of the mediation process is called the separate caucus or private caucus.
Now that we're in our separate caucus, I want to remind each of you that everything we say in this room is going to be confidential.
By the way, two things. First of all, most business mediations will go to the caucus very early. There's not a lot of joint sessions. They want to go to their separate rooms, and then you've got the mediator kind of this shuttle diplomacy type situation where the mediator is just going back and forth between the rooms. And that's oftentimes the case in cases that tend to be more business in nature. This thing that he said, hey, everything you say to me is strictly confidential. Just know I have heard some nightmare stories where the people open up, they're like, okay, it's confidential, I'll tell you this and this and this. And the mediator then takes this information and then they can sort of see, they get this information from both sides, they can see if there's an overlap and there's other possible agreements, they can see right away if there's going to be a deal made. I have heard of cases where mediators accidentally disclose some of that information. So just be aware that even though a mediator gives you this line of, hey, we're in caucus now, you can tell me anything, be mindful of the fact that, okay, worst case scenario, the other side finds out about this, what will happen? Because it does happen sometimes.
I won't say or repeat anything in the other room that you tell me here unless I'm specifically authorized to do so. So this is your chance to really open up. Tell me what's important in this case to you. It's okay to reveal any weaknesses or concerns you have in your case. It's our chance to sort of flesh out some of those issues and really kind of bring them out into the daylight and take a good look at them without fear that the other side is going to see them.
There will be many separate.
I mean, as you can tell, this is where if you have a mediator who's super directive, it can be really, really helpful, right? You, as you said, tell me the weaknesses in your case, tell me cases that are on the other side or whatever. The attorney might be able to divulge some of the weaknesses and some of the, like, this is what I'm afraid of to go to litigation or whatever. If you have a mediator who's very, very experienced, who may have tried, 1,000 of these cases in a courtroom, it's at that point that the mediator can be like, okay, this is where I think, based on what you told me, this is where I think, this is where I think the chances are. They might give you advice. I mean, when you get this training in law schools, they will tell the mediators, don't tell them anything. You cannot give them any kind of legal advice. Give them no kind of guidance. My own suspicion is that the mediators who get hired are oftentimes people who will, not necessarily, you don't want to cross the line and start giving legal advice, but they will give out enough information that it's very helpful to the party and to feel comfortable to make a deal. So that, I mean, just as you're doing, as we're thinking about mediation and we'll be involved in mediation ourselves, think about this idea, the information. To what extent do you want to disclose mediation? To what extent do you want to disclose information to the mediator? And then if you had somebody who was a very knowledgeable mediator, what impact did that have on the mediation if the mediator was telling you or your client that kind of expertise and experience?
Our caucuses during the mediation, and the mediator will be moving back and forth from room to room in a form of shuttle diplomacy. Typically, in check with the mediator in your case, everything discussed during the separate caucus will be completely confidential, not to be disclosed to the other side unless you permit such disclosures. As a result, your lawyer will likely encourage you to speak freely and openly with the mediator during the separate caucuses. This will allow the mediator to understand what is important to you and your candid assessment of both the strengths and weaknesses of your position.
Let me remind y'all that when we're in this private caucus, everything we talk about in here is going to be held confidential. I'm not going to tell anybody in the other room anything we talk about unless you authorize me to do that.
Keep in mind that the mediator is not there to judge you or declare whether you are right or wrong. The mediator is not your lawyer or there to give you legal advice. But the mediator will reality test all sides.
Tell me what's at the heart of the conflict for you. Let's learn about it from your perspective. I think we're making progress in the other room. I have a good feeling about us being able to resolve it today. But let's go ahead and flesh it out a little bit so that I can understand exactly how you view this whole thing.
During reality testing, the mediator will ask open-ended questions which permit you and your lawyer to more critically and objectively evaluate your positions.
By the way, two things. I think that as a mediator, you have to be careful. He said you have to be very careful of everything that you say because I think it will be very critically scrutinized, especially by the lawyers. So if you as a mediator say something like, I really think we're going to be able to settle today. Part of what I think what you're signaling to the other side is, hey, there's overlap. We're going to have a deal here. So you're giving, I think that you might be giving away information about the other party's bottom line. I think that you have to be very careful as a mediator. You want to be upbeat, positive, but I think that you have to be very careful. Anything that you say, how can it be read by the other side? Because as a lawyer representing your client, you'd love to get those signals. But if you get to the position of being a mediator, I think you have to be very careful about that.
As your lawyer has no doubt told you, no case is perfect. And every case has its good and bad points.
What sort of counterproposal do you want to develop? What message do you want them to hear in this?
Well, it's hard for me to respond to that, Greg, because I made an offer, as I pointed out, on behalf of my client that we do have room to negotiate. But it's really hard for me to try to formulate a strategy to respond to an offer which is so ridiculously low, not commensurate even with any reasonable recognition for damages.
You should remember that the mediator is not just reality testing you. He is reality testing all sides so that all parties may objectively evaluate their risk and so that constructive negotiations can occur.
At the close of the first separate caucus, the mediator will solicit your first settlement proposal. This begins the negotiation phase of the process.
But, you know, it's really not my place, Tom, to tell you what's a good move and how to be received in the other room, but am I hearing you authorizing me to take that back in as a counteroffer?
Sure.
Let me go ahead and do that then, and I'll come back and visit with you after I've had a chance to deliver your counter proposal.
Let me just say one thing. I mean, I hope that you learn one thing, an important thing about negotiation is this idea of first offer. Right? I mean, I have this idea that sometimes the negotiation is essentially over after the first offer. And if you don't have really, really good objective criteria, it can be dangerous taking the first offer. Because you might throw something out and not realize you could have gotten a way better deal. So just carry all, and that's why I say the building blocks of ADR is to learn about negotiation. So now you're in mediation, which is just a facilitated negotiation. So if the mediator is trying to get you to make the first offer, think about this with your client, explaining it to your client. You know what, we don't have very good objective criteria. We have no idea if this is really work. Whatever. Let's let them do it. So always think about sort of everything you learn in negotiation, apply it to mediation. And even if the mediator is saying, well, you know, it's not, at this point, I always turn to this party to make the first offer. You can always say, so what? You know, ask the other side if they want to make the first offer. At this point, we're not prepared to make the first offer. Right? If the other side hasn't taken a negotiation class, they might take you up on it. And all I'm saying is to think about all this in sort of a strategic way from a negotiation vantage point, not just mediation.
Understand that offer is probably not going to be acceptable to you, Terry, but what sort of counter proposal do you want to develop? What message do you want them to hear in this?
All the things that I'm saying here are confidential, right? You're not going to tell the other side what I'm saying. I'd really like to get this case settled. This is an entire year of nightmare out of my life. I've just gotten married, and my husband and I are about to buy a house. I'd really like to get this thing over with and start my life. I feel like there's a stopping point from the date of the wreck to now, and if I can end this today in some way with a reasonable settlement, then I'd like to do that.
In many respects, a mediation is a supervised negotiation, with the mediator acting as the traffic cop of the negotiation. Mediation is a process, and negotiation is a process. Negotiations often take time, and you should expect several rounds of proposals and counter-proposals during the mediation process. Negotiation may often be frustrating, but keep in mind that what matters is where the negotiations end, not where they begin.
Mediation is, by its very nature, a flexible process, and the mediator will make procedural determinations depending upon the situation that develops. For example, a mediator might decide, after splitting the parties into separate caucuses, to call for a second joint session to allow for additional direct communication. In the appropriate case, a mediator might wish to host a lawyer-only caucus to discuss a legal issue, or, and only with the permission of counsel, a mediator might want to bring the parties together without the lawyers. But by the way, a lot of mediators will try this. Hey, we'd like to have the parties just talk to each other. Do you mind, counsel, stepping outside of it? Think strategically before you go into a mediation whether you want that to take place. And you can always, when anybody proposes that, don't hesitate to say, I'm going to talk to my client or whatever. Step outside and talk strategically to your client. Look, you really want to be in this conversation without counsel? I mean, that's difficult, right? You've got your clients in there just as a mediator. Your client might make a bad deal. And so you have to be a little bit careful because you don't want to sound like you're condescending with the client. But I think that you have to be prepared for a mediator at some point who's probably going to recommend that. And you have to be talking over to your client and know beforehand whether or not you're going to let that take place. Flexibility of the process, unlike the rigidity. By the way, I would very much hesitate to let my client go in there and talk alone with the other side of the meeting. I mean, I probably wouldn't let them do it. Of course, it depends on the case, it depends on the client, but I'm just saying.
trial procedure allows for greater creativity. As we've discussed, a mediator may not force the parties to settle, but if the parties do reach an agreement at mediation, the agreement will be reduced to writing in something called a memorandum of agreement. Typically, the mediator will prepare the first draft of the memorandum of agreement and will present it to all the lawyers and parties to review for form, content, and accuracy. After all the suggestions.
By the way, it's interesting. I mean, you're essentially writing out a contract. Kate Elliott and Frank Elliott, professors Elliott and Elliott, have written on this in Texas. It can be a little bit, you don't necessarily agree. There becomes this question of, are you practicing law? And you don't want to cross the line into practicing law. And they have written a couple articles. One of them, I believe, advocates, like, look, if you're a mediator, he just advise you to write up the contract. They're saying, look, some of this is still being tested, some of it is still being kind of litigated. You don't necessarily want to write up the contract. You know that from your contract, that whoever writes up a contract, that if it eventually goes to litigation, it would be construed against the drafter, right? So you might recommend to the party, hey, why don't you jointly write this, right? They know what they want the deal to say, and as a leader, I would certainly tell them, hey, why don't you jointly write this, run it by your counsel, get them to do it, and their counsel to do it. It takes the pressure off of you as a mediator being accused of practicing law. And I think that's the recommendation that King and Frank Elliott came to. There was a kind of a smaller article on this, and it's still being worked out. And I would advise that you not be in the position of being a mediator.
That is made and agreed to. The mediator will present the final draft to all parties and counsel for signature. To complete this process, I'm going to hand it to each of you for your signature, and this will be a fully binding agreement. The dispute will be resolved.
By the way, explain your client, because a lot of people think, oh, mediation is kind of a, I can get out of it if I don't like my deal. I can come back the next day. No, explain to them that you've got this process where, yeah, you're going to go in and chat with the other side, but at the point where you reduce it to a contract, it's a whole different world, right? When you're taking contracts, now it's serious. It can be enforced in the courts by courts, and it's a whole different, and people, who tried to get out of deals that they've made that they've reduced the contract, it's hard to get out of. And, you can claim, that the other side pressured you, or, fraud. You can make different claims that will normally get you out of a contract situation, but for the most part, they're going to be locked in. And explain that. I think that a lot of people feel like, oh, mediation is sort of law of life. I can get out of this if I don't like it the next day. No. If it's reduced to contract, they're probably going to be locked in.
Congratulations. In virtually all states, a signed mediated agreement is an enforceable agreement and may be enforced as any other contract might be.
Yes, that's the case everywhere.
Simply put, once the parties and their counsel have signed a memorandum of agreement, it is binding. After the mediation, the lawyers will also prepare the final release, dismissal, and settlement documents that will be filed with the court and which will reflect the agreements set out in the mediated agreement. Tom, Terry, congratulations. I hope you're happy.
Thank you. After the mediated agreement is signed, the parties may want to get together for a few minutes to exchange handshakes and wish each other well.
I've never seen that. I've never, ever seen that. And that's great if you're in a mediation like that. But I almost guarantee you won't. You're not going to be throwing rocks at each other still, but you're going to go do some good things.
This is referred to as the closure phase of the mediation process. In fact, after a resolution is reached, the parties often feel a sense of relief, and they desire to exchange a gesture of conciliation. A mediator will not force you to do this, but will usually ask if you wish for an opportunity to say goodbye and extend mutual wishes of goodwill.
By the way, I've been in mediations where, people they'll make the deal, but they literally have told me, I want to walk out separately and keep them in there so we can get to our car.
Let's take a few moments to discuss some of the most frequently asked questions about mediation. Eric, what are some of the primary advantages of mediation?
Greg, I think there really are three special advantages to the mediation process. First, the parties have the unique ability to craft their own resolution to their dispute instead of abdicating that responsibility to a judge or jury. Second, the mediation process is by its very nature creative.
By the way, this whole community emancipation, I definitely agree with that. And as I said before, you can do anything as long as it's not illegal, right? So you can be very creative and come up with stuff that would never happen in court. And I'm always surprised in mediations at how sometimes how little the resolution is being directed by the law. Right? We have this whole, oftentimes, a whole body of case law directing people towards a specific kind of settlement. The case law acts really as an objective criteria. Hey, if we go to court, this is likely how to come out. And yet, for whatever reason, oftentimes, I don't know if the lawyers just don't know the body of case law or whatever, but oftentimes they will achieve a settlement that seems to have nothing to do with what would happen if they were to go to court. But I find fascinating.
Parties are not limited by rules of law or procedure to arrive at an agreement that makes sense to them. And finally, I think it provides parties with an opportunity to gain closure on very difficult emotional problems, and in some instances, actually gain conciliation, which is very beneficial to how people feel.
Can a mediator force a party to settle?
Absolutely not. The mediation process is not designed to be coercive or forcing anybody to do anything they don't want to do.
It's definitely not coercive, but I told you before about these elected mediators. If you have a mediator who's, an retired judge, they can be somewhat coercive. I mean, if they say to a party, look, the deal that you're getting here is better than anything you'll ever get in court. You never approach this kind of deal in court. It's not coercive, and sometimes the lawyer even really appreciates the fact that the mediator is letting the client know that. So I wouldn't call it crossing the line into coerciveness, but I definitely some of these mediators can be quite directive and really signal to the client, hey, take this deal.
And maybe the mediation process is consensual. The parties reach an agreement if they want to. To be sure, the mediator will encourage all sides to move towards an agreement. And a mediator can simply not make anybody do anything that they don't want to do.
If one party is convinced that they're right, isn't a trial the best place for them to find justice?
Greg, the answer to that question is that ultimately, if you go to trial, it is true that a judge or a jury is going to make a determination that someone is right and someone is wrong. The reality is that before you get to that trial, no one really knows who is going to be found right and who's going to be found wrong. In a mediation, it's not a matter of who is right and who is wrong. It is a matter of negotiating a settlement between the two.
If the parties reach an agreement during the mediation, can one side back out of the agreement?
If an agreement is reached and signed by all the parties during the mediation, it becomes a binding agreement between or among the parties.
What should the parties bring to the mediation?
You might want to bring a notepad and something to write with during the mediation process. Additionally, you might want to bring something to read, books, magazines, newspapers, and the like, something to do while the mediator is reading and conferring with the other side.
Is there a court reporter present at the mediation?
There is no court reporter present at the mediation, and at a mediation, the parties aren't really giving testimony. This is not a deposition, it is not a trial. The mediation process encourages people to speak openly and candidly, and in fact, no record is made of the mediation itself.
How should the parties address the mediator?
Well, you certainly don't call the mediator your honor, because the mediator is not a judge. Most mediators at the very beginning of the process encourage and ask if it's okay for everybody to refer to each other by first name. Alternatively, Mr. Jones, Ms. Smith would be an acceptable way to refer to the mediator, not your honor.
Finally, what happens if the case does not settle during the mediation?
In many instances, even though the case doesn't settle at the session itself, sometimes within days or weeks after the session, the matter does in fact resolve as a result of the mediation process. In other instances, the issues between the parties are narrow, and even though an agreement is not reached, it reduces the number of days for trial. Finally, mediators as a general proposition continue to follow up on the cases and encourage the lawyers and parties to continue their discussions, very often resulting in a final settlement of the case. We hope that you now have a better sense of what will happen at mediation, will be more comfortable in the process. You know, mediation has become a national and international approach to resolving conflicts. We think this is true for many reasons: avoidance of delay, minimizing costs, and reducing risks. But beyond those conventional reasons, it just makes sense for individuals and businesses to find better and more humane ways to solve problems and resolve conflicts. It's difficult to quantify the value of peace of mind or achieving conciliation, but we know such things are important to people. We wish you a positive mediation experience and congratulate you on participating in this worthy process.
All right. Any questions about mediation? Okay. Okay. Well, all right. We're gonna have to put off until Monday something else I want to do, but we don't have time to go through this. Those things that I was going to do, we'll do them Monday. The stuff online. I think it would just take too long. And so it's just more follow-up on the ethics stuff, because I really do have this idea that I think I want people to learn the rules. It's great just as a professional responsibility class, but there's a lot of incentive to law and negotiation. Sometimes people get it. We don't have much time. There's I want to show you a videotape. Ethics, we talked about sort of ethics in relationship to negotiation in sort of a narrow sense. I told you we figured out exactly sort of what you can lie about in a negotiation. There was the comment to Rule 4.01 that specifically says that you can lie. People lie in negotiations. They lie about the line. They lie about what something's worth. They lie about whether they're representing. They can lie about those things. They can lie about whether or not they're representing something in negotiation. And so you have sort of, kind of specific rules on ethics. And I think that's what the professional responsibility classes get into, the specific rules. And even when we watched the videotape on Monday, we really went through the different things that happened in the negotiation that may have crossed an ethical line. We came up with 5 or 6 specific rules that may have been broken. The videotape that I want to show you is this. Because I think when it comes to ethics, people make bad decisions. And it has nothing to do with the rules. It has everything to do with judgment. And the videotape that I'm about to show you, I think a judge, I like YouTube because sometimes it'll show clips of things that otherwise you don't get to see. This was videotape in the courtroom, and it was one of those, I lived in Las Vegas, and I went to the courthouse all the time to do mediations. This was in the courthouse in Las Vegas. This was one of those News 8 IT investigations or whatever, and it was just a quick 5-minute videotape. I want us to watch it though, and I will say this, it's a disturbing videotape. It's a disturbing videotape. It's a videotape of a woman who was in the courtroom. She claimed that she was sexually assaulted by a guard in the courtroom. And the reason I want to show it is this, because you might say, well, what does that have to do with an ADR class? I think it has very much to do with an ADR class in terms of the ethics stuff that we've talked about so far are more narrowly tailored to the ADR stuff. And I'll get into more ethical stuff with the mediation, specific rules about the ethics of mediation. The reason I love this piece of videotape so much is I think that the judge made a very poor judgment in how she handled this matter. And it's an ethical matter. Basically, she had, and this is what will happen in the tape, because it's a little bit of a confusing tape. There's a woman who's in the courtroom, and I forget what the case is. She might be something about a divorce or something. She claims that she was sexually assaulted. Now, the tape will show, the camera will show her, so the camera will be focused on her. And then there's another woman who's making the allegation is her child. So the judge essentially is ignoring what's going on and trying to complain to the kid. And I'll tell you what happened in this case. But I think that to me, it's a perfect illustration of, you can learn all the rules you want about ethics, but when it comes time to sort of perform in a job, I think people oftentimes sort of literally lose their minds. And she's so far away, I think, from how she should have been the judge I'm talking about, how she could have approached the situation, and what she should have done ethically. So the thing I want you to think about is, if you were the judge in this situation, what would you have done? That's the question I want you to ask. If you were the judge, what would you have done? So, let me just see if I can find it. All right, so this one is IT.
Multiple employees and managers at the Clark County Family Court are under investigation for allegedly covering up a sexual assault by a court marshal. The I-Team has uncovered video showing a woman claiming a court marshal sexually assaulted her. She later was arrested by that same marshal, who has since been fired. The I-Team's Nathan Baca here now to show us how an internal affairs investigation is revealing much larger problems at Family Court.
Dave, it's not just one single case. There's multiple marshals involved and allegations ranging from sexual assaults to choking a citizen in court. This investigation begins with a 2011 video we've uncovered showing family court marshals arresting a woman because she claimed one of them sexually assaulted her. A warning. Some of the details of the story may be disturbing to some.
So I'm just going to close the case out and dissolve the order.
All right, thank you.
Okay.
Monica Contreras came to family court with her 2-year-old daughter. She was in court for only a few minutes on a routine divorce case. According to internal court documents reviewed by the I-Team, Family Court Marshal Ron Fox ordered Contreras into a waiting room by herself for an unexplainable drug search. Contreras says Marshal Fox touched her buttocks, breast, and ordered her to lift up her shirt. A later internal investigation validated her claims. Contreras went right back into the same courtroom to tell hearing master Patricia Doninger her requests to have a female marshal search her were ignored.
I think I'd rather have a female. And you wouldn't encourage. And I was just offended by it. I'm just offended that he asked me to do that.
Okay, so the story stands. Hands up. Contreras pleads as Marshal James Kenyon begins to arrest her.
Oh, what, sir?
Hold on.
Okay, why would I be arrested? Can you please tell me?
Turn around, put your hands behind your back.
Can you please tell me?
Turn around, put your hands behind your back. False allegations made against the police officer, so.
What?
We looked and could find no law supporting that arrest, let alone any law allowing an alleged sexual assault victim to be arrested by the alleged assaulter.
Jimmy, I got court. I still have to do this, so arrest her. I take the kids. We're done.
Why would you do that to me, sir?
Because you're making
I'm
false
not being
allegations.
assaulted.
After repeated attempts by marshals to get Contreras to recant her story, she breaks down.
Let me go home, please. Let me go. It was all lies. I don't want to feel anything. It was all lies. All lies. All lies. All lies. Please stop.
We can do this easy, or we can do this to her.
Marshal Fox tells Contreras the only way she can avoid jail is to step up to the microphone and recant. Contreras agrees, but does the opposite.
You asked me to lift through my shirt without a witness. You asked me to lift through the shirt without a witness.
For 4 minutes, Contreras pleaded to hearing master Patricia Doninger to hear her. Doninger didn't look at the alleged sexual assault victim, deciding instead to play with Contreras' daughter.
How can you do this to me? How can you what? How can you what?
Contreras' 2-year-old daughter confronts the marshals arresting her mother.
He said, can you please pull my shirt without a witness? And I said, I don't think that's a good idea.
Yes, I do, yeah.
Contreras kisses her daughter before being sent to jail. Her young daughter sent to Child Haven. 2 months later, Contreras filed a complaint with Court Martial Internal Affairs. Sources tell the I-Team investigators were shocked. They never heard of the alleged courthouse sexual assault from Family Court Lieutenant Steve Rushfield. After a 6-month internal affairs investigation, Marshal Ron Fox was fired. Nobody from Clark County told Monica Contreras that. She found out because we found her. Contreras asked that we blur her face.
I just hope I did the right thing by telling Internal Affairs. It makes me feel good because now I know that I was right.
We went to the top of Clark County Court Administration. They released a statement reading, "Court personnel are prohibited from commenting on the video because it's a personnel matter. When the actions of any district court employee are called into question, the court immediately responds by conducting a fair, thorough investigation and upon completion, taking appropriate action." Even though Marshal Fox was fired, sources tell the I-Team Clark County is widening its investigation into why this incident and a growing number of assault allegations were never reported by family court management to Internal Affairs.
All right, so, my question is, this is what I'm reading by. I learned a lot of rules about that. I'm sort of stunned by the way that the judge. By the way, the judge was fired. But what would you have done if you were in that situation as a judge? I mean, right, it's unfolding in your courtroom, right? This bomb is going off in your courtroom. What do you do? This is how I think most ethical things happen. It's not that you're sitting around talking about some cool ethical thing in the classroom. This is how ethics unfolds. So what would you do? You're a judge and this is unfolding in front of you. She chose to play with the little kid. What would you do? Yeah.
I would have asked her to come back to my chambers, and I would have brought her into the child museum, someone that she felt responsible enough to kind of watch her child while we talked in chambers about what had happened.
Okay. What would happen with police officers?
Well, then I don't think it's a personnel issue. I think it's a criminal issue. So I would then call whoever it would be in charge and the police or whoever at the courthouse and have them start an investigation.
Okay. You know, I heard kind of stories like you. I heard things, but I never sort of ran into things. But I hear things. But I don't know. You know, it's probably Las Vegas always seems a bad rap. I think these things happen in every city. But yeah, I heard of things too. Yeah. What do y'all think? What do y'all think her reason was for it?
That might still, evidently, the other guy that was arresting her was Baylor, right? So maybe they had some sort of relationship, maybe the Baylor and the Marshall had some, like, you know, I mean, they try to stick together maybe, sure, you know, so.
I think that could be part of it. You're dealing with, I mean, I watched the judges over there. That bailiff was probably in her courtroom every day, and that guy who was fired, the guy who was fired probably, you know, worked in her courtroom every day. I mean, you know these people, they literally are there to guard your life. You know, is that an acceptable reason to behave like she did? I don't think so. And yet I can certainly understand there maybe being a relationship there where you have to witness the work of the person, and trust the person literally with your life. That could play a role. There's a hand back there. Oh, sure. Oh, absolutely. No, absolutely. No, judges are, people run towards them, try to attack them. I mean, there's a reason for this gun. They have stun guns, and I think they're armed. I mean, there's a reason. There's some really tough characters who run through courthouses. But, you know, I think it's just a stunning piece of news. And mostly because I think people who are made judges and magistrates, in my mind, they're kind of at the top of the legal world in many, many respects. Every judge that I've ever worked with has been an amazing person. I would say it's incredible. other things and money. And so when I'm keeping interrupted repeatedly by an expert, I'm simply Oscar. And I do think that it's very relevant in the conversation of ethics because I know that the way ethics is taught is to give you, little scenarios and everything. I think this is how ethics unfolds every day. I think she made a horrible choice. I think that's certainly one way to do it. You're in the chambers. I mean, if you don't know what to do, she has all the powers that you have as the judge. I'd be like, at least if I didn't know what to do, there are judges all around, up and down this corridor. I'd be like, everybody breathe. I'm bringing in 3 more judges and we're going to deal with this. I mean, I don't know what the answer would be, but I would certainly call it a people. And I just found it astonishing that she chose to just watch the kid. I mean, luckily we now have videotape so we can sort of see these things. But until you watch it on videotape, you just can't believe it. And I think it's just more relevant to ethics than almost any other thing I can teach you about. Other questions? We're going to get to the things you would ask on our next session. So when I sent that email, please send me your groups of 3, and if not, I'll assign you.
Do you know the guy with the red beard over there? Sean. Yeah. He said we might want to merge. Want to go talk to him real quick? So might go. Okay. You just want to see what happens? Okay.
See the one groups of 4, right?
Yeah. Because he's with 2, so I was thinking he asked me if we wanted to merge together, but.
Well, worst comes to worst. I'd rather just do a group of 3.
Yeah.
Schedules and coordinate.
Right.
I don't care who we're with.
What do you think would be a good time to meet? Do you want to do it just that Monday?
The 30th? I'd rather not.
Well, so you want to do the Thanksgiving week, or? I'll be here.
I gotta be over here.
Monday, Tuesday.
How long is it?
Let's make sure for an hour, at least an hour, let's say. And then, of course, prep time, so like 30 minutes on each side. Well, no. I'd say about an hour and 15 minutes. That's how much we should.
I wonder if we could do it Wednesday afternoon.
Before Thanksgiving?
Yeah. Before this class. Do the class before this?
No. Yeah, I'm not going to do that. Wait a minute, we don't have class on Wednesday.
Yeah, we do.
We do.
We don't have class in here on Monday.
Hey, Jessica, do you know if we have class here on the Wednesday before Thanksgiving? Okay.
I'm not good at remembering those things.
Yeah. Oh, that'd be all right.
But we don't have class on that Monday.
Right. That's correct.
That way, for some reason we can't finish on
Oh, on Monday. Okay, yeah. Well, hopefully we can do it all in one sitting.
Yeah, I hope so. But if something happens,
Right.
somebody gets sick or something.
Yeah.
Send me another one.
I hear you got something published?
Yeah, actually, the Hegelian dialectics and U.S. election law. Remember I was talking to you about it? No, it's just basic, yeah, take care. No. Well, I do my best to kind of, my goal was to explain it to an audience or an audience that doesn't understand philosophy at all. So I definitely tried to put it most simplistic. I mean, not trying to be just basic English. Simple English.
That's great.
I don't think that's how everything works. Yeah. I gotta be, real mistake. Yeah. Yeah. I was just like, if I would have known you were great, I'm trying to put effort in. I might have actually looked over it once before I said it.
Yeah, this is a 20-minute thing.
I wrote it while Farewell.
Right. That's great. I'm trying. That's how you.
Are we gonna have a really cool camera on you? Right. Oh, that would be so much editing. Yeah. I'm working on it, but I've been reading and collecting. It's really hard for me to just like write. I've got to collect something and then so I've been doing this rather than actually my additional work.
That's how it works.
That helps me.
Good, I appreciate it. Yeah.
Oh, really? Yeah.
Good.
I would do it. Oh my gosh, thank you.
All right, no worries.
Yeah. Yeah.
That's what you do.
They constantly
Oh, right.
I think it was
But what else?
Okay. Well,
I'm actually excited about it.
have you ever done a news search on Webcam?
Yes, I did.
Yeah, on Webcam you can set up so you can get notifications. I can show you really quick.
Yeah.
So I do this.
Yeah, no, I think. Yeah. Right. Well, if you, especially if you try. But yeah, I'd try that. But no, it's great because I mean just.
It'll run
Well, here's another question I had.
Yeah.
You know,
No, you're
this
right.
video, there's different ways of using it. I don't even know.
Right.
But I mean, what do you think?
Doesn't matter. No, doesn't matter.
I was thinking.
Well. I'm president. Are you president?
Yeah,
Okay,
I made that group.
So this is my feedback. Even though they're all
Yeah, I mean, I'm not a good speaker, that's why I'm saying that. So I don't know the rules at all.
You can still, right, you still. But I don't necessarily.
I think knowing yourself is important.
Yeah.
Often it's just
Right. Yeah, that's great. I gotta run. It's great you formed that group.
Oh,
That's
yeah,
great.
yeah. You know who told me? Well, you know Brian Garner, I went to Saul's speech and he gave that video. I told him I'm a terrible speaker. When we did our first year of oral arguments, I think it was like 5 minutes, I had 60 of us. I'm completely nervous. I usually, I think I've gotten better.
Oh, that's good. So this is.
Yeah, he told me to come.
I'm glad you did.
Inspiration goes to it's passed down.
I think that's
No, I'm
great.
just joking.
Well, it gives everybody the opportunity.
Yeah.
Which is great.
If you want to join.
Yeah. I'll talk to you later.
Okay, bye-bye. See you. Greetings, friends. Howdy.